I would just like to say that that this is a work in progress, and I'm writing this paper with Shai Shoham, who is here, and he is the assistant of the president of the military appeal court in Judea and Samaria, Colonel Mishnayot, who has just presented here, and I'll be very grateful for your comments. So I'm going to refer perhaps at least thematically to the presentations that have been given in the morning regarding the military courts. I'm talking about the juvenile justice system, not only here but also in the coalition provisional authority administration in previously occupied Iraq, and I will be talking more about the theoretical, the normative framework that perhaps I would say but this is our view, would be, I will relate to the normative framework that we think that should be applicable generally in occupied territories, with a specific application to the Israeli case or the occupied territory case. I will not have the time to delve into the relevant data of human rights violations either in Iraq or in the OPT. It is in the paper, but here I will mainly be referring to the theoretical framework. So, what I would just now present a brief sketch of this paper, and then I will go into the themes themselves. So, in the first section, we present a brief history of the changing nature of legal regimes of occupation. We claim that the regimes of occupation have been changing from what was traditionally called belligerent occupation and short-term belligerent occupation to long-term occupation in the OPT, and new kind of occupation called transformative occupation with specific goals for this kind of occupation in Iraq, for example. And then in the second section, we suggest that we discuss the legal framework that should be applied in laws, in regimes of occupation, and as usually the natural regime would be the regime of IHL, of international humanitarian law. Then we subscribe to the concept that has been emerging in the last maybe 10 years or even before, that there should be a co-application with a human rights law. I'm not going to spend too much time about that because a lot have been said about that, but we adhere to this concept because it is very relevant in our mind to the application of a just juvenile justice system. And I will explain why we think it is so. And the section that I will not be referring to deals with the claims of violations of the rules, of the legal frameworks that have been already established in the occupied territories, either in Iraq or in the OPT. I will briefly suggest which standards of international human rights law we think that are also relevant, that are specifically relevant to juvenile justice, should be employed in juvenile justice system in occupied territories. And then I would say how we think that they should be implemented as Israel objects to direct application of human rights, of international human rights treaty law in the occupied territories. So we would think that perhaps direct application through the military legislation in the territories would be better accomplishing the challenges or the goals of just juvenile justice system. So as for the changing nature of the law of occupation, well, what has happened in the recent decades, 2 decades perhaps, is that, of course, that new states have been emerging as states have been disintegrating. Yugoslavia, the USSR, for example, South Sudan, and of course there has been also an ongoing struggle for decolonization in the OPT and also in East Timor, and of course the increasing level of terrorist attacks also influences the situation in occupied territory. And I would like also to mention here that this is a point that we should be developing later in the article, and we have not yet reached that point. We have not been discussing the question of what happens when there often arise armed conflicts within occupied territories. We refer only to the general framework of occupation, and we did not yet investigate the relationships between the regime of occupation and its relations with the regime of armed conflict, the law of armed conflict. And so what happened because of the history that I have just described here was that also new types of also new sorts of occupation regimes emerged, such as the transformative occupation regime that I referred to in formerly occupied Iraq, for example. And this regime had, of course, a specific goal to help the population in the occupied territory to restore a new civil order, or to help build up a new sort of nation state. Whereas in the OPT, what happened is different, and it's just, I mean, the Israeli occupation in the Palestinian territories did not have the goal of building up a new regime in the territory, or a new independent regime in the territory, but rather it just changed from a short-term occupation to a long-term one. And what happened is that these changes, of course, affect to our mind the legal framework in these territories. As of course, the foundations of the traditional law of occupation are the Fourth Hague Convention of 1907 and the Fourth Geneva Convention of 1949, and these instruments, which are considered customary international law, of course, establish the framework of the belligerent occupations regimes and their goals and their duties, and the main duties of the occupant, which are to preserve the daily routine life of the occupied population, also trying to create some kind of a harmonized system that secures both the right of the occupied population on the one hand and the security interests of the occupant on the other hand. So the main thrust of the international law of occupation is in fact to provide an interstitial set of rules for the administration of the territory until its fate, of course, is decided. And it should only be preserving public order, but of course it should not have any ambitions to change the basic laws that are governing, that were governing the state before it was occupied. And of course the one who is actually implementing those laws, both of the military laws and the international law, is the military commander, sort of the incarnation of sovereignty in the occupied territory, as was repeated several times by the Supreme Court of Israel. But what happened during the long time of occupation in the OPT is that the question was how the military commander should apply the considerations of both preserving the daily routine life of the occupied population on the one hand, and on the other hand, how it should preserve the security interests of the occupying force. And with the presence of settlers in the territories, of course, this also had effects on how to actually employ the discretion of the military commander. And so the Supreme Court of Israel reached the conclusion of a need for a sort of dynamic view of the duties of the military commander. And as I said, I think it adopts a dynamic view which actually widens the authorization given to the military commander. But I think that this widened discretion should be limited, or it should not be widened when it does not consider the benefit of the occupied population, which is, of course, the protected persons. In contrast to that, the mandate that was given to the coalition in the formerly occupied Iraq was much broader, and this is for a reason, because of the goals of the transformative occupation regime that was set up there. And if its goals were also supported by the UN Security Council, its goals were to advance efforts to restore and establish national and local institutions for representative governance, then this could mean that this broader mandate for having widened considerations for the occupying force is legitimate. In contrast to what happens, I think, in the OPT. And it is also maybe important to mention that the coalition provisional authority administration did not even refer to the regime that was implemented in the occupied territories over there as occupation, even though it was rather called the transitional administration, even though the UN indeed refer, and the international community indeed refer to this regime as an occupation. So now, of course, there's different roles and objectives of the regimes, both in Israel, in the occupied territories and in Iraq, of course, also affect the legal framework to be applied in each of these territories. And I do subscribe to the concept that in both cases, international human rights law should be applied perhaps simultaneously with international humanitarian law, or at least as a complementary law of the lex specialis, which is the international humanitarian law, which serves both to solve, the IHRL, the international human rights law, serves both to solve lacunas in IHL, and also it validates the legitimacy of the involvement of international supervisory mechanisms in situations of occupation. We would see later on that Israel does not accept the intervention of supervisory international mechanisms, but I will later on refer to that. So I think that when a transformative occupant rather would agree to or should at least agree to the application of human rights law, as it actually supports the idea of building up a new state, which is the enterprise in which he is involved, then perhaps the belligerent occupation, the long-term belligerent occupation, would firstly object to that kind of application of laws, as it would claim that international humanitarian law is sufficient for preserving the rights of the occupied population, and also for living up to his duties as an occupant in the occupied territory. And however, this may be true to a short-term occupation, which was, of course, the prototype of the belligerent occupation regimes that was set up by international law. But the long-term occupant, resembles more, to our mind, to some kind of a sovereign, as with its relations with the occupied population, and it faces more and more demands from the population to be protected from what you may call improper exercise of governmental power. And so, under these circumstances, I think that human rights law is a much more effective tool to be used by the long belligerent occupant in order to fulfill the goals of what was at first intended by the laws of belligerent occupation. Now, the application of HRL is very much relevant to the establishment of a just juvenile justice system. Because, of course, the juvenile justice systems, bases its interest very much on international human rights norms and standards, with the idea of the rehabilitation of the juvenile, with the idea that the court serves as the juvenile's voice sometimes, and all of these. All of these goals of the juvenile justice system in general are very much so in the juvenile justice system in occupied territories, and they should be generally based on international human rights law more than on international humanitarian law, to our mind. Yet it is to be decided which instruments, specific instruments of international human rights law that substantiate those norms, that refer to detention of juveniles, that of course refer to the fact of them having a speedy trial that has the goal of their rehabilitation. So it is to be decided which instruments of international human rights law are to be implemented in the occupied territories. And of course, this depends on what we call the under its jurisdiction clause of human rights treaties, such as the ICCPR, the International Covenant on Civil and Political Rights, which, if it is interpreted in a way that widens the jurisdiction over persons who are under the effective control of the occupying force, or whenever a state can exercise its public powers on a territory of another state, then there is a possibility for the application of the ICCPR, and these things have been said. I'm just repeating them. These are not new ideas. And we also know that the case for the application of the CRC, the Convention of the Rights of the Child, is more complicated, as we have there the Article 38, which perhaps excludes the applicability of the Convention in times of armed conflict. But yet there are also non-binding instruments, soft law instruments, such as the United Nations standard minimum rules for the administration of juvenile justice, the Beijing rules, the UNICEF principles and guidelines on children associated with armed forces or armed groups, which are called the Paris principles. And all of these soft law norms also could be applied in occupied territories, as they don't have any statutory demand for their application. And the specific norms that I'm referring to, of course, I think I've said that, refer to the question of detention, the fact that human rights treaties demand that juveniles would be separated from adults, that the main goal for their adjudication is their rehabilitation, and so on and so forth, and also the or the soft law instruments that I have mentioned repeat these ideas. So now the question is, of course, how would they be implemented in the occupied territories when Israel, as I said in the beginning, objects to the direct application of human rights treaty laws. It says that Israel interprets the under its jurisdiction law in a very narrow sense, and it also says that it has never declared that the human rights treaty laws would be applied extraterritorially of Israel. And so, as we have this practical problems, so we believe that if, and this is maybe the second best option, but it's still better than not applying at all international human rights law norms, then perhaps it should be implemented as has kind of indirectly done, as was told us, Colonel Mishnayot and also Smadar, I think, also mentioned these, that, for example, the juvenile courts that have been established in the occupied territories, in the Palestinian occupied territories, are in fact, in a way, an indirect application, in a sense, of norms of international human rights law norms. Of course, it is not a direct application of human rights or treaty law, but it absorbs the ideas and the norms of international human rights law. And so I think this is kind of the second best option. Of course, we would not have the possibility to apply the supervisory international mechanisms for making sure that Israel actually complies with its obligations under international human rights law, but at least the norms of international human rights law would be in such a way applied and help the occupying force to reach the goals of the belligerent occupation in a better way. Okay, just to conclude, I would say that we still have to remember, as I said, that of course the belligerent occupation should be temporary, and of course here talking about temporary is kind of problematic, as we now see this occupation going on and we don't really see its ending in the near future. And yet, of course, it is crucial to remember that the belligerent occupation must pertain to the basic tenet of the belligerent occupation regime, which is that the roles of the occupying power should be limited to keep the order and safety of the occupied territory and population, and not make too many changes in the legal regime in the territory. Thank you very much.